if you read the US Constitution, you see that there's all sorts of power-conferring rules in there. Today, we're talking more about HLA Hart's rule of recognition. In particular, we're talking about something that was written by Scott Shapiro, where Shapiro is just trying to say exactly what the rule of recognition is. Because even though when we read Hart there was lots to say about the rule of recognition, it's still pretty vague exactly what type of rule it is. In the first part of the reading, there was a whole bunch of stuff that we don't need to focus on. Shapiro basically summarizes Chapter 5 of the concept of law. We don't need to go over that. If you want a recap of that, go back and watch my video about Chapter 5 of the concept of law.
Okay, I'm just gonna freeze myself with my eyes closed right here to mention that this video really won't make sense unless you've already read Chapter 5 of the concept of law, or at minimum, watched my video explaining Chapter 5. You don't have to read the rest of the book to understand this, but you do need Chapter 5. Okay, now I'm gonna see if I can unfreeze myself.
Shapiro makes a few helpful points that we need to remember. The rule of recognition is a social rule, so it comes into existence because of the actions and thoughts and words of members of the society, namely officials of the legal system. It exists because of certain social facts. It's a secondary rule because it's a rule about rules. And also, Shapiro doesn't mention this, but the rule of recognition explains the unity of the legal system. It's the thing on Hart's theory that explains why disparate laws, some about taxation, some about traffic, and all that sort of stuff, how those are laws of one system, and how the laws of some other system, how the laws, in France or in Russia or in Nigeria, those are laws of different legal systems. Well, it's because there's one rule of recognition at the top of a hierarchy, and if another rule falls somewhere within that hierarchy, then it's a rule of that one legal system. Now we get to the actually interesting question in the selection from Shapiro that we read, and that is his answer to the question, what is the form of the rule of recognition? What Hart mostly says about the rule of recognition is that it's a test of legal validity, a test that other rules have to pass in order to be laws. And so what test really means here is it means a set of criteria, like just a set of characteristics that a rule has to have in order to be a rule of the system. That's what Hart says, but Shapiro notes that the rule of recognition can't be merely a test. It can't just be a set of criteria because, this is how Shapiro puts it, Hart only recognizes two types of rules. These are the only types of rules that he seems to think there are because these are the only types that he mentions. He seems to think that all rules are either duty imposing, right? Those are ordinary rules, like a rule that says do not murder, that imposes a duty on citizens not to murder, or a rule that says you must pay your taxes on April 15th, that imposes a duty to pay your taxes on that date, right? And then the other type of rule that Hart recognizes are power-conferring rules. These are the ones that don't say what someone must or must not do, but instead they give people a normative power or a kind of authority. So there's a power-conferring rule that gives individuals the power to write a legally valid will to distribute their estate, their property, their wealth, or whatever, right? Or there is a power-conferring rule that gives the governor the power to pardon criminals. So if we operate under the assumption that these are the only types of rules that there are on Hart's picture, then, a mere test is neither, right? A mere set of criteria, doesn't necessarily impose a duty or confer a power. Say that there's some criteria, this is a point that Shapiro makes, say that there's some criteria for counting as a bachelor. There's a test of whether you're a bachelor. In order to be a bachelor, you need to be unmarried and you need to be a man. That's what it takes to be a bachelor. That's a set of criteria. That's a test for bachelorhood. You take each thing and you check. Is it a man? Is it unmarried? If it's Mount Everest, then it's unmarried, but it's not a man. It's not a person at all, right? If it's me, right, I'm a man, but I'm married, so I'm not a bachelor. But that fact, the fact that there's this set of criteria that you have to meet in order to be a bachelor, does that impose any duties on anyone? No. Does it confer any powers or any authority on anyone? No. So the rule of recognition, if it's going to be a rule, can't just be a mere test. So which is it? Is the rule of recognition power conferring or duty imposing? We know it's not a mere test, even though that's the way Hart talks about it. Well, if these are the only two options, which one is it? First, consider power conferring rules. Is the rule of recognition a power conferring rule? Shapiro thinks it can't be for two reasons. The first reason is that it would make the rule of recognition identical with the rule of change, at least of many legal systems. Here's an example of a potential power-conferring rule of recognition for English law or British law. This is a power-conferring rule. It confers on the Queen in Parliament, which is actually an abstract entity. It's not exactly the Queen. It confers on the Queen in Parliament the authority to make British law. Maybe that's the rule of recognition of the British legal system. Well, Shapiro thinks that that doesn't work because that's just the rule of change for the British legal system. And the assumption is, Shapiro doesn't spell this out, the assumption is that the rule of recognition can't be identical with the rule of change, not even contingently within a particular legal system. This, by the way, I will just mention, seems like a mistake to me. It seems to me that Hart distinguishes the rule of recognition from the rule of change, and so it's going to be possible in some cases for those rules to be distinct. You know, there's some rule that recognizes who gets to make laws in the first place, and another rule that recognizes who gets to modify them or change them. I don't see why that's not possible. But I also don't see why it's not possible on Hart's view for the rule of recognition and the rule of change in a particular legal system to just be stated in a single rule. There be one rule, one articulated rule that counts as both for that legal system. Maybe that's how it works for most legal systems. I don't see why it couldn't work that way. Anyway, that's one of the problems that Shapiro thinks there is with the claim that the rule of recognition is power conferring. You know, one of the problems is it collapses. It collapses the rule of recognition and the rule or rules of change. Okay, that's one potential problem. I don't think that that's actually such a big problem, but Shapiro raises a second problem which seems to me more powerful or more decisive or whatever, and that's the following. There are customary rules that really are parts of many legal systems. These customary rules, they are themselves social rules that bubbled up and at some point became recognized by the legal system as having legal status. But they were never, created by someone with the authority to confer power. So if the rule of recognition is a power conferring rule, that is, if it gives someone the authority to make law, and then all the laws that they make count as valid laws of the legal system, and that's how we tell which are valid laws of the legal system, well, then all of the laws that they didn't create won't count as valid laws of the legal system. But there are laws that no one created, but that do count as valid laws of the legal system, and those are customary laws. So the second problem is that this way of making out the rule of recognition can't handle customary laws. That, it seems like, is a legitimate problem for understanding the rule of recognition as a power-conferring rule, or so it seems to me. So Shapiro concludes that the rule of recognition really has to be a duty-imposing rule. Specifically, he thinks it's a duty that legal officials have to enforce or apply certain rules. Duty-imposing rules it's just worth pointing out, are always of the form S must phi. S is just going to stand in for a person or a collection of people, and phi for a certain action, right? So-and-so has to do something, right? And this action, of course, can be construed negatively. It can be, citizens must not murder, right? Where not murder is the action. Anyway, okay, that's the form of all duty-imposing rules. Shapiro is going to fill in the individuals with some kind of legal officials. The action or the behavior is that they're going to have to, apply rules that meet criteria, X, Y, and Z, or whatever. Here we go. We've got Shapiro's answer to what the rule of recognition is. So there's a question that remains for Shapiro, which is, why does Hart keep talking about the rule of recognition as if it were a test, if it's really, well, some duty-imposing rule that gives some duty to legal officials? Here's Shapiro's answer, and in my view, this is the insight of the paper, or of the selection of the paper that we read for today. This is, if he's got any insight, it's this. Notice that when you structure a duty-imposing rule like this, it builds in a test, right here. Built into the content of this duty-imposing rule, legal officials must apply rules that meet criteria X, Y, and Z, whatever those criteria are. This is just a set of criteria. Here it is. This is the test. It's built in to the rule. If you have a rule that says you've got to look at this set of criteria, see if a rule meets this set of criteria, and then apply that rule if it does, and if it doesn't, then ignore it, right? If you've got a rule like that, then, well, you've got a test built in, a test of legal validity. We'll count all of the rules as valid if they meet this set of criteria. So there's a duty-imposing rule out there that functions within a legal system as a test of legal validity. Notice two things here. One, if the rule of recognition is a duty-imposing rule, then Shapiro concludes the US Constitution can't be the rule of recognition of the United States legal system. Because if you just read the Constitution, which we did in this course last time, that was the last reading in this course, right, was the US Constitution. If you read the US Constitution, you see that there's all sorts of power-conferring rules in there. The US Constitution can't be a duty-imposing rule. It's like a collection of a whole bunch of other rules, many of which are not duty-imposing at all, but are power-conferring. Now, at this point, I don't know if this is really decisive, because it could be maybe, you'd have to work out the details, but maybe it could be that in the set of criteria, you mention a whole bunch of power-conferring rules when you're spelling out the criteria. So the fact that the US Constitution includes a bunch of power-conferring rules doesn't mean that the US Constitution is not, broadly speaking, a duty-imposing rule like this. It could be that the power-conferring rules that are mentioned inside the Constitution are, well, part of the criteria or among the criteria of legal validity that's inside the broader duty-imposing rule. Anyway, that's just a thing. But anyway, Shapiro concludes that the US Constitution is not identical with the rule of recognition of the US legal system. Okay, and then there's this question of which officials are we talking about? Which legal officials have this duty? Is it every, government representative, every police officer, every judge? The answer that Shapiro settles on is that it's the judges, right? Specifically, the rule of recognition applies to courts and other legal officials. Well, they don't have this duty, but different secondary rules apply to them, namely the rules of change in particular, and in some cases, the rules of adjudication apply to legal officials who are not themselves judges, or they apply to institutions other than courts. Now we arrive at the most confusing or puzzling part of the selection that we read for today, and that was this last paragraph. There was this last paragraph that we read today, and it was about justiciability. Is that how you spell it? No, it's not how you spell it. There's an I there. I need to explain what this is if you're going to understand this paragraph. Justiciability is the feature by which a case is legitimately decidable by a court. Here's an example. One condition for justiciability is that a case cannot be moot. The idea is this: if two relatives are fighting over what happens to their grandpa, right, who is incapacitated, that is, whether the grandfather goes on some life support or something like that, right, and they sue one another, these two grandchildren, let's say. They sue one another, and then, unfortunately, the grandfather passes away. Well then, if the court case is still going on, the court will rule, typically, that the case is non-justiciable. That is, the court doesn't have the authority or the capacity to issue a ruling because there's actually no longer any disagreement about what to do because there's nothing to do, because the grandfather has already died, right? And so the case is moot. In order for a case to be the kind of thing that a court can hear and then issue a ruling on, the case cannot be moot. Another thing is that in order to be justiciable, cases have to be ripe. Here's what this means. Let's say you and I have a contract, and you're supposed to do something. You've agreed to do it. It's in the contract. And I think you're not going to do it. You're not supposed to do it for another few months, but I have reason to think you won't. So I sue you for breaking the contract, for breach of contract. But you haven't breached it yet. Well, in this case, our dispute or the case or whatever, it's not ripe. It hasn't ripened. It hasn't reached maturity, right? You haven't actually breached the contract. So the court can't hear and issue a ruling on this case because it's not ripe yet. Okay, here's the one that's relevant. There's another condition on whether or not a court can hear a case and issue a ruling on it, and that is that it can't deal with cannot be a political question. This is a pretty murky one. And there have been cases where the Supreme Court has ruled throughout the 20th century that, this is an issue that is better decided by the legislature or the executive branch. And so we, the court, who view ourselves as in some sense apolitical, we're not going to hear this case. We're not going to issue a ruling. This case is, it's not justiciable because it deals with a political question. This is called the political question doctrine or whatever. It's just another condition that a case has to satisfy in order for the court to view itself as legitimately able to issue a ruling. Well, here's the thing. These political questions, they're still matters of law. So an example of a political question might be how the House of Representatives in Congress, how the House of Representatives deals with its own internal regulations of who can raise objections and points and all that sort of stuff, right? The court may decide this is a political question. This is for the House of Representatives to decide among themselves. It's non-justiciable. But nonetheless, so they can't decide it, the courts don't have a duty to apply those rules, the rules about the internal rules of the House of Representatives. The courts don't have a duty to apply those rules, but that's still a part of the US legal system. Those are still legally valid rules, even if the court doesn't apply them. Well, this is a problem for the rule of recognition understood in this way as a duty that's specifically had by courts. Here's the thing. If the test for whether or not some rule is part of the legal system is legally valid, if the test for that is whether the courts have a duty to apply it, well, then we'll get the result that all of these political matters, all of these rules of like the House of Representatives and other similar rules, they're not part of the US legal system. and that's a bizarre, counterintuitive result. Shapiro just mentions this. This you can either understand as a problem for Hart, or you can understand it as a problem for his particular interpretation that understands courts specifically as the kind of legal officials who have this duty to apply these rules. It's a problem, he mentions it at the end, and I wanted you to understand what the problem is. And that's it.